Okay, good afternoon, everybody, and welcome to today's webinar, episode 8 of Association Continuity in a COVID World. My name is Craig Vaughn. I'm the president of Castle. For those of you who don't know Castle, we specialize in the management of condominiums, apartments, and HOAs in Florida. We partner with about 300 associations through 7 offices and 1,750 teammates. Welcome back for those of you who are rejoining us. And welcome to our new webinar participants. We're excited to have you. As a reminder, Rose said, please feel free to chat in your questions throughout the webinar, and I'll try and work them into the conversation. You will recall that last week we moved our presentation, our webinar, to 4 o'clock because we thought it would be more appropriate for you to drink when we're talking. And interestingly, guys, when the survey results came back, we were way better when our participants drink. So we'll have to do that for future episodes, but we're back to 12 o'clock. We'll keep the 12 o'clock slot for a while. Back by popular demand this week is polling. We are making a few changes, mostly based on the feedback we've received. So we have some new questions. I would ask our webinar participants when the polling questions come up to answer them promptly so that I can give the feedback back to you as we go through the presentation today. Let's start with a quick question. Let's find out who we have in our audience today. So Rose, if you could post the first question, what type of community do you live in? And is your community a 55 and better community? So our participants are answering that, Jeff and Michael. I wanted to get you to introduce your firm quickly, but I'm going to start with Michael this week because Michael, Jeff, just so you know, Michael told me he didn't think you did a good job last week, so he wanted to take over introducing the firm. So Michael,
I would never say that. Jeff does an outstanding job every time.
He does a good job. But Michael, will you?
Sure.
Mike was just feeling left out.
I will try to match up. But anyway, yes. Thank you, Craig. And welcome everybody again. Good afternoon. I guess we're past the noon hour. Mike Bender here with Jeff Rembaum from K. Bender Rembaum, Community Association Lawyers. For those who are not aware, that is the practice that we are in and have been since 1991. We are 19 lawyers strong. We offer community association general counsel services, including the assistance with delinquencies, complex litigation, and day-to-day association matters out of our offices in Pompano Beach, Palm Beach Gardens, and Hillsborough in Tampa, Hillsborough County. We also have office locations by appointment in Miami-Dade, and we assist, we have in excess of 1,200 communities that we work with throughout the state, proudly assisting our boards and management teams with their day-to-day operations, their legal matters regarding associations. I'm happy to say 9 of our attorneys are board certified in condominium plan unit development law. And Jeff, would you like to add anything more to what I'm sharing?
Well, sure. We have lots of seminars that we put out, lots of webinars that we're doing right now online for board certification classes, assistance animal classes, and if you receive our email blast, then you know what those schedules are. If not, you could send Mike or me an email. We're easy to find, and we'll get you onto our distribution list. We publish, Robert K. publishes his column at least once a month or so, Legal Morsels. I publish Rembaum's Association Roundup, and we just try to keep everybody informed, clients and non-clients alike, so that you know what's happening with new legislation and new court cases as they affect Florida's community associations. Mike, I hope that intro was everything you wanted it to be.
It was absolutely what I was looking for. And just to conclude then, I want to remind everyone, and Jeff nailed it at the very end, legislation is another aspect that our firm is very active in. I am the chair of the Florida Legislative Alliance, which is the legislative arm of CAI. Jeff and I and a few other attorneys, including Sean Brown, who runs our Tampa office, are very active with the Florida Bar Subcommittee, Condominium Plan Unit Development. So we also are very active in that regard. This is what we love. We do it all the time, and we hope today you guys will get a lot more information that you can funnel through and use.
2 things. I thank you very much, guys. And I will say to our webinar participants, I do subscribe to the Rembaum Roundup. I read it religiously. Jeff is an excellent summary always. So I do appreciate you sending that out and highly recommend it to everybody who's listening out there. Michael made a good point. Jeff and Michael are here to give their opinion on the topics we're discussing, and they're not intending to give advice to your specific association. So we would encourage you, if you have questions, relative to your association, reach out to your own professionals. So guys, with that, let's jump in. I thought we'd change the routine up a little bit. You know, in the last several sessions, we've asked our participants about the number of pools and gyms open, the number of clubhouses closed. We have seen about the same results. You know, half of the pools are open, half of the gyms are open, and most of the clubhouses are still closed. So today we want to move on to a little bit more of running your association, the business of your association in our current environment. With that in mind, I'd just like to go through the agenda for today. So we're going to have current legislative update. We got some exciting news coming out of the court system. So that's, Jeff, interesting. We're going to talk about non-essential visitors and a check-in on what's going on and what you guys are doing with non-essential visitors. We're going to talk about meetings, electronic correspondence. So whether or not you've given the opportunity for your residents to accept correspondence, official correspondence electronically. So we'll talk through the nuances of that. Electronic voting, and then of course answer any questions. So before we jump into a current legislative update, Rose, can you post to see who we have in the audience today? Are they up?
Yep.
It was, yeah.
So, you know, half and half, co-ops and condos, pretty close, actually 60-40, condos versus HOAs. And of our HOAs, about 40-60 of the 55 and better space. So another good type of dispersion of the, another good group of diverse group of listeners, which is wonderful. Guys, on July 7th, the governor issued an executive order extending the state of an emergency for an additional 60 days, now set to expire, I think, on September 4th. From a regional standpoint, you know, no new orders in Palm Beach. There was a new order in Broward, updated again last night, Michael, I think you told me this morning. So can you take us through what's new in Broward?
I'd be happy to. Yeah, executive order, it was 20-22 issued last week, and then 20-23 was issued yesterday. So I'll just touch upon them briefly. And essentially, just I want to read one thing from the 2022 order, because each of these orders and all of the counties do have a basis, a whereas clause as to why they're issuing the order. And this one specifically says, whereas recent reports indicate that a significant amount of COVID-19 transmission is resulting from social gatherings at residential or other properties, street parties, neighborhood gatherings, and other gatherings and settings. And so in order to help control the pandemic and avoid further spread, this is, it's of the utmost importance that all persons take reasonable measures to minimize contagion, including ensuring visiting homes, etc. So that was the premise behind this. It's like, hey, the number, you know, where we were in May, all of a sudden, boom, everybody jacked up. So they're trying to figure out different ways, and they're thinking, hey, let's all just kind of take a little bit of our you know, self-interest here, work together. And that was the base of the order. So with that in mind, a curfew has been issued in Broward County. It took effect July 17th, 11 p.m., and it's from 11 p.m. to 5 a.m. It was set to expire tomorrow, basically Saturday morning at 5 a.m. Yesterday's order extended it through the weekend. So now it's set to expire 5 a.m. on Monday, which I believe is August 3rd. So that's the first order. So it was a curfew. They also, they have a section on prohibiting of gatherings, and it addresses private gatherings. And it's a violation of the Broward County order for any group to gather at a residential property, whether single family or multifamily, whether indoors or outdoors, where the gathering exceeds 10 people. The residents of the household and parents and minor child of those residents don't count in that number. Okay, so that was it. There also is also an order with regard to gatherings at other establishments. Again, no more than 10 people at any time, and then there are certain exceptions. There is the violations. What they had in the original order, which was modified initially, was that if you had a gathering, and there were people, and by the way, there was also responsibility for facial masks. That if you had a gathering, that people were required to wear masks, which is part of the order from earlier this month. And that if you had gatherings in violation of the 10, or people weren't properly wearing their facial masks, the individuals who were in violation could be cited, and the owner of the property could be cited for each person over the 10. That does not apply if you are renting your property for more than 6 months. If you're renting your property for more than 6 months, then your tenant would be the responsible party. But if it's a shorter rental than that, or if you're the owner or occupier, you could be cited. The new order did clarify that you could be cited for your own violations, but if people are on your property, presumably outside and not in compliance, they would be cited, not the owner of the property. There is the other big item has to do with short-term rentals, and the order clarified that short-term vacation rentals that are not actively managed by an on-site owner or on-site management company with staffing or security on site for 24 hours a day, they could not open. They could not allow vacation rentals. That started July 20th, and it goes through August 20th. Okay, there are exceptions for persons performing military, emergency, governmental health, or infrastructure response to COVID-19. But you are not, otherwise that is limited. And that order, and you're required, the order from yesterday basically says that you now need to provide the information for that person who is doing the 24-hour management. You need to give email contact information to the county. To a reopening@broward.org. You have to provide the contact name and telephone number for the 24/7 staffing or security personnel to reopening@broward.org in order for you to be in further compliance. And lastly, it clarifies that in addition to hot tubs, saunas, steam rooms, jacuzzis, all are to remain closed unless you're in a single family or a duplex. So that's what the Broward County orders, that's what the orders are. And they're basically trying to, they're taking the facial mask order from July 7th, earlier in July, and now just saying, hey, in addition to that, we're also now going to be addressing these gatherings of people, private or public gatherings, which they believe has been a big part of the spread.
Michael, thanks. I think that's going to be huge relief for a number of our associations, specifically related to the short-term rental issue, because I know there are, concerns. So that's great news in Broward.
Yeah.
Jeff,
Before Jeff, 2 quick points to remind everyone. One, the same. That's the Broward County order. That is the restrictions in place at a minimum. Your municipalities can, and the order specifically says your municipalities can provide stricter guidelines, and you as an association can provide stricter guidelines. Again, you need a proper process. Get with your association council. Make sure you're doing these things properly.
Outstanding. Jeff, nothing new in Palm Beach, but Palm Beach has some very specific guidelines. Can you run through those for us? And specifically, we have some questions from our pre-registration regarding monitoring of pools if they're open.
Sure, I will certainly address that. I also want to address, before the moment passes, Edward, who's listening today, watching, asked a very important question, and it's coming up more and more and more. And it's under the emergency orders. Can a board make decisions via email and then ratify them later at a regular board meeting? And what we're advising our clients is use the emergency powers if you need to. If it's related to an exigent need, if it's related to a COVID-19 need, but to use the emergency powers to obviate the 48-hour meeting notice, to obviate the requirement that would allow unit owners and members of the HOA to provide their comments. If that's at all possible, then you should be facilitating it. Bottom line on that is you should not use the emergency order, the emergency powers as an end run to run the, as an end run around the normal legislation to run the association. And that's the best answer I think I can provide to that particular question. But I wanted to address that because it is very, very important that the emergency powers not be abused, but used when needed.
We're going to talk further about meetings after. So
sure. That's a good one then for then as well. All right, let's jump into some swimming pools and get all wet. Very, very important. Pool capacity is limited to the amount of people that can go in the pool and be socially distant. They must maintain social distance. Locker rooms and shower facilities remain closed. Pool deck seating needs to be rearranged so you're complying with the CDC guidelines on social distancing. Remember, when we talk about swimming pools in Palm Beach County, we have to talk about the requirements themselves, the notice, and then the compliance. So we talked about the requirements, maintain social distancing, real simple. The notice, well, very important because the staff that's authorized to manage the pool or their designee, which could be pool staff, Management staff, volunteers, board members, or any other authorized persons must provide notice, either electronically, by mail, or by posting, that all users of the community pool abide by any and all social distance guidelines, including but not limited to CDC guidelines, and said users of the community pool bear the responsibility of such compliance and assume the full risk of utilizing the community pool. Remember, it has to be provided one of several ways. We suggest to our clients you both post it at the pool, plus also deliver it via mail or through email, however your community association may provide its notice to the members at their official addresses. Then the compliance itself may be accomplished by any reasonable means, including but not limited to periodic spot checks, video monitoring, other electronic monitoring, and or compliance hotlines to allow for reporting of violations that are thereafter promptly investigated. So that's very, very important. All right, the association does have that responsibility to ensure the compliance and ensure it by one of those aforementioned means. So I think that covers the swimming pools fairly well. Then we have the face mask requirement in Palm Beach County. Palm Beach County being different because why should Palm Beach, Broward, and Miami-Dade all get together and have the same face mask requirements? Well, that would make too much sense for government bureaucracy. So in Palm Beach County, you simply wear your face mask whenever you cannot be socially distanced with people from outside of your household. In addition to that requirement, and that would really apply to our HOAs and condos, to the common elements in the condo, the common areas in the homeowner associations. But beyond that, facial coverings must be worn by all persons other than those specifically exempted. And there's a category of people who are exempted, such as certain medical professionals when necessary. But you must wear the facial covering when obtaining any good or service, or otherwise visiting or working in any business or establishment, including entering, exiting, or otherwise moving around within the establishment. Such businesses and establishments include restaurants, retail establishments, hotels, grocery stores, gyms, pharmacies, indoor recreational facilities, and vehicles for hire. So Michael, you can continue your vehicle for hire.
Excellent. But I wear a mask all the time.
Yeah.
Outstanding.
Good stuff, Jeff. Listen, thank you, Jeff. You know, nothing really new in the legislative front, as we said, but there was a case decided in Palm Beach last week relative to wearing a mask. Can you kind of give us an outline of the case and what was decided and maybe how it affects our world?
Absolutely. The Palm Beach County mask case. There's actually 3 of these that have been around the state, Palm Beach County being the 3rd. The case itself, for anybody that wants to go read it, you can go into Google, type in Palm Beach County court case number 2020 CA 006920. That was 2020 CA 006920, and it should pull up for you. There were 4 plaintiffs suing Palm Beach County. They were seeking an injunction against having to wear the mask. Palm Beach County entered its mask order on June 24th. Surprisingly, the court's order, which ultimately denied the plaintiff's verified emergency motion for a temporary injunction, was issued on July 27th, 2020. And in explaining what happened, I will go through 3 parts: the plaintiff's position, the county's position, the court's analysis. So we'll talk about what the plaintiff said, we'll talk about how the county responded, and then we'll talk about what the court said in response to those 2 arguments. Obviously, I can't go through the whole case, so I will just give you the high points. So the plaintiff's position, those people saying no one should have to wear a mask under any circumstances. Why? Here's why. These were their core arguments. Number 1, as to the right of privacy, the plaintiffs argue the requirement to wear a facial covering in public spaces constitutes an impermissible intrusion into their private lives, including an individual's right to refuse medical treatment. Point 2, as to their due process rights, the plaintiffs argue that the mask ordinance is vague, arbitrary, and unreasonable, and not backed by any compelling state interest or facts to support that interest. Number 3, they argue they had no adequate remedy at law because money damages were not available for a violation of privacy rights. That one was thrown in just to comply with the requirements to get an injunction. Number 4, that they will suffer irreparable harm because of their loss of their fundamental freedoms. Number 5, the plaintiffs point out the fact that the mask ordinance is enforceable by law enforcement and can result in being charged with a 2nd-degree misdemeanor and fines. Number 6, the plaintiffs argue that the public interest is served by preventing the placement of undue, unconstitutional burdens on people. Number 7, and this is the last one of the plaintiff's arguments, whether the order is inconsistent with general law in violation of the Florida Constitution and whether the order violates a plaintiff's right to free speech under the Florida Constitution. To all those arguments, the county disputes the plaintiff's argument that it has a substantial likelihood of success on the merits and that the public interest is served by refusing to enforce Emergency Order Number 12. Emergency Order 12 is the Palm Beach County order requiring face masks. The county's position, the county then says, as to the plaintiff's likelihood of success on the merit, the county asserts that there is no constitutional right to privacy that has been infringed at all by the mask ordinance because you have no reasonable expectation of privacy regarding your physical appearance in a public place. There's no reasonable expectation of privacy in a person's decision to unwittingly subject others to illness and death. And finally, requiring the wearing of facial coverings does not constitute medical treatment or otherwise intrude upon an individual's right to make medical decisions. Number 2, the county asserts that no right to due process has been infringed because the mask ordinance is not vague at all. Individuals are not left to guess what is required in the county's order number 12. Third argument from the county, they argue that the emergency order 12 would even pass, for you constitutional buffs out there, the strict scrutiny test necessary because the government's interest in preventing widespread death and injury from COVID-19 is in fact compelling. And the order is very narrowly tailored to advance that interest. And that's what's important there. Then the court's legal analysis, and they start out, you can tell where the court's going as soon as you read the first sentence. The plaintiffs have failed to show by competent substantial evidence that they have a substantial likelihood, bless you, that they have a substantial likelihood of success on the merits or that the public interest would be served by enjoining the enforcement of order number 12. Like the 3 other courts which have addressed this issue to date, this court finds no constitutional right is infringed by the mask ordinance mandate to wear facial covering, and that the requirement to wear such a covering has a clear rational basis based on the protection of public health. The other cases, for those that are interested, were in Alachua County and in Leon County. Emergency Order 12 does not infringe on any cognizable privacy right of individuals in Palm Beach County. Florida Constitution does not at all guarantee against intrusion into the life of an individual. There's no reasonable expectation of privacy when you cover your nose in public places. Order number 12 does not infringe an individual's right to refuse medical treatment. Wearing a mask, face covering, is less intrusive than the preventive measure of placing fluoride in drinking water, which has always been held by this court district as not being a medical procedure and therefore constitutional. Emergency Order 12 is not unconstitutionally vague. And finally, it does not violate due process for being arbitrary, capricious, or discriminatory. And the court goes on with 3 more short statements. Plaintiff's argument and evidence that facial coverings are unable to completely prevent the spread of COVID-19 cannot establish that the order itself is arbitrary and irrational. The fact that the wisdom of a regulation can be disputed does not, especially at a time of pandemic, does not make the requirement to wear the mask unreasonable. And finally, the plaintiffs have not shown the public interest is served by enjoining emergency order number 12. In other words, the plaintiffs got slammed in this court decision. Pretty strong.
Sounds like a vote.
That was a mouthful. That was a lot.
Yeah, I think in summary, the judge essentially said you have no constitutional right to infect others with COVID-19.
You got it. Exactly. In fact, the court ends it with a final paragraph. As the community tries desperately to navigate the tumultuous seas presented by COVID-19, it is reasonable and logical that our elected officials are throwing the citizens of Palm Beach County a lifeline in an attempt to ameliorate the spread of this deadly, unbridled, and widespread disease.
Well, guys, you know, it's funny. That's great news. I think it makes a lot of sense to me. I don't know, but it's not stopping our residents from not wearing masks in their community, and it leads us right into the issue of enforcement, specifically around the rules and wearing masks. So I want to find out what our participants are doing. So Rose, can you please post poll question number 13? And for those communities represented, are you fining and or suspending use rights for COVID-19, COVID-related violations? And
Craig,
while we answer that question, Michael, I want to reach
before
back.
before you ask me the next question, I just wanted to address, there were a couple of items that addressed the an opening statement I made about Broward County. So I just wanted to hit those real quick.
Sure.
First of all, the gather, this did come up, and I'm gonna say, when it talks about the gathering of less than 10 people, I've been asked, hey, does this mean we can't have more than 10 at the pool or in the gym? The gatherings, in my opinion, and I think our opinion is, you have in Broward County, now I'm talking about Broward County specifically, because that's where this private gathering order is limited. It's not, to my knowledge, in Palm Beach, Miami-Dade, or any other county in the state. This is a Broward County order. There are requirements in Broward County that pools are limited to residents only, and family members, non-resident family members, if the board has allowed it. In that regard, if you were invited, you couldn't have more than 10 family members with you at the pool, in my opinion, but that doesn't stop more than 10 people from being at the pool, because different residents are allowed to be at the pool so long as they're otherwise following the requirements for social distancing, etc. The issue of having to wear a mask on the pool deck is something that we addressed last time, but I will reiterate my opinion, that is, and the Broward County order has said, as long as you can social distance on the pool deck, a mask is not required. According to Broward County, municipalities may offer it differently. I had someone in Pompano Beach tell me that the Pompano Beach code officer came out to their community, said pool decks, you need a mask on the pool deck. In Fort Lauderdale, they said, no, you don't. They followed the Broward County requirement of social distancing. So you do need to know what your municipality says, and as a board, you can make stricter requirements if you so desire. Dade County, to my knowledge, has no new orders issued. So what I am specifically addressing is Broward County.
Thanks, Michael. Excuse me, Rose, can you post the results of our question? Are you fining and or suspending use rights for COVID-related violations? Wow, 76% of those who voted said they are not fining or suspending use rights for COVID-related violations. Michael, it doesn't, I guess, really surprise me, because the process to go through for fining and suspending use rights is a bit cumbersome. Maybe doesn't get a quick response. Last week, you shared with our audience some other tools that the board can use to, get right down to the enforcement. Can you reiterate those for us?
Sure. And I know that, and I appreciate the number of participants we have on the program today. And I would ask, it would be very helpful if all of you take a moment to answer these polls, because I think it's good intel for us and also for everybody else. And with regard to that, the question with regard to, are you fining or suspending? I think a big problem with fining or suspending use rights is the ability to have an independent committee created, and that applies to the HOA or the condo or the co-op. And that's, I think, the biggest hindrance to the fining or suspending of use rights for these reasons, because when you're fining or suspending for rule violations, you do need to have this independent committee of 3 owners who are not members of the board, directors or officers, employees, or spouses, parents, siblings of them. And that, if you can't get 3 people to volunteer, you're not going to have that committee. But I do think if you have the ability to have that committee, or even encourage people to be finding a grievance committee in a limited basis just for these issues, it's something worth discussing with your council and putting in play. The other item I mentioned the last time we spoke about was, if you've properly adopted guidelines and people are in violation of those guidelines, and we're talking specifically about COVID related, but quite frankly, this applies to any of your covenants, any of your rules, then you should be sending them violation notices. You're going to want to be able to support that they are in violation, and by either having eyewitness test, people who've seen it and will be willing to step up and say they saw it in writing. If you can videotape, or if you have security video, or if people are using their phones. Again, I've had a conversation with the board yesterday on this. I'm not suggesting that you say to someone, hey, you don't need to wear a mask, and if they get aggressive and you take your phone up and snap a picture in their face, I don't recommend that. That's encouraging an altercation, physical or verbal, that we would like to avoid, but report violations to management or security so that they can write up reports. And if they're not responding to emails or courtesy letters of violations from management or the board, then should refer that over to your council and have the council send a more aggressive demand for cease and desist. They're in violation. You can take legal action with their violations of rules, regulations, restrictions, as long as they've all been properly passed and approved. And you should consider doing that. Hopefully residents who are in violation will not need to be reached out by council. Something else I talked about was if you have the ability in your documents now to address, let's just say one of the issues that comes up is if associations are not in compliance and they get fined by the county or by this municipalities for violations, and the issue relates to one or two particular individuals who are consistently ignoring. And like I said, I had a situation in Hallandale Beach where the code officer came out because another owner reported violations. And when they came out, they acknowledged that the association had put up proper signage, they noticed efforts of security and other staff trying to obtain compliance, but they said, if we come back and we see violations, we're going to cite the association, not necessarily the individual who is the repeat violator. So to that, I said, discuss with your council the possibility of updating your documents. And that if necessary, or to see if you have the ability, if you do have a financial damage caused by an individual, that can be documented and supported, that you have the ability to go back to that individual if you're not fining them, go back to the individual to get the association to get reimbursed for that monetary damage. These are just some other ideas that you should consider in addition to the fining process and the suspension of use rights process.
Awesome.
And I'd like to add into that as well, Craig, that if any of our associations have adopted COVID-related rules using the emergency powers, and then, so you've created a rule that said you're going to be fined $100 if you're not wearing a face mask. And you did that using the emergency powers. So you had a meeting, maybe you had consultation with the board, but no members were there, et cetera, and so forth. You usually just the emergency powers. It was 1, 2, 3, quick. Well, then now fast forward and you want to enforce that because the person isn't complying. They're still not complying and they're not paying the $100, which is now maybe up to $600 because you caught them 6 times and you want to go into court. Well, if you've never taken the time to formally adopt that rule, you're going to be in uncharted territory if you try to go into a courtroom type setting using the emergency powers saying, yeah, well, we adopted it in the face mask, $100 every time you don't wear it. And we did that on July 15th. And we did it using the emergency powers. And you have minutes from that. We don't know how a court's going to look at that. What we do know is if after you've used the emergency powers at your first available opportunity at a properly noticed board meeting, you have then ratified that rule, all right, by repromulgating it, if you will, readopting it at a properly noticed board meeting, you're going to be in a much better enforcement position. And it's going to remove a lot of the questions regarding the emergency powers. So bear that in mind as well, listeners.
Excellent. Okay, guys, that's fantastic. What I want to let's move on to a quick check-in on non-essential visitors. And Rose, I'd ask you to post poll question number 14. This is a little bit changed from last time, but if permitting non-essential visitors, have you adopted any additional rules concerning their visits? So will you answer that question? You know, in the last 3 webinars, we polled you regarding whether or not you were actually allowing contractors, realtors, family, and other non-essential guests. The results have been very consistent. Almost all communities are allowing, the first 3 are allowing contractors, realtors, and family, about 75% allowing other non-essential guests. So you asked us, and what we really want to know now is, that seemed like a lot, and we speculated that people were adopting additional rules relative to those guests. So let's see, can we post the results, Rose? Let's see who's adopting some additional rules and what they are. So guys, if permitting non-essential visitors, have you adopted any additional rules? Temperature checks, 24% of those that responded, 13 of 54. Mask and glove requirements, most. Limiting the number of visitors, limiting the hours of visitation, requiring a hold harmless agreement, a few out there. So it looks like our suspicion was right. There were additional rules that were adopted. Jeff, any comments?
Sure. I have a client, you know, sometimes as lawyers, we learn our best lessons from our very own clients. And one of our clients has a really unique approach to allowing realtors into the buildings, into the condominium buildings for unit showings for potential sales. And what they've done is created a system, two blocks of time during the week. And I forget the actual days, I'll make them up, Tuesday and Saturday from 2 to 4. And that way, what they've arranged to do is have cleaning services come in to do an extra clean, if you will, in the lobby area, extra sterilization after those times. And then to avoid any type of business damage claim from an owner, they've also said, if that doesn't work for you for any reason, then please contact the board, let us know, and we'll make other accommodations for you. And I thought that was a really clever way of maintaining a safe environment, a clean, sterile environment, and still allowing the unit showings to take place so that you could try to thwart a business damage claim where an owner later says, I couldn't sell my unit because you wouldn't let my realtor in. I thought that was really unique. Mike, you got anything to add?
Sorry, Jeff.
No, I mean, I think, again, I think the point Jeff made is really good, is that, we have a lot of clients that we represent, as do you, Craig, and you guys I would be a little bit more on the front line to know what restrictions might be put in place. A lot of our clients do reach out to us, but quite a lot more don't necessarily reach out to us. They put things in place, and I think they get them from these webinars, and they get some guidance. And this list of these 5 items that we had here, this, as you know, we discussed what are some of those that we're aware of, and I think these are the top 5. I think I'm not surprised that the only thing I'm surprised about is that there are 6 out of the 54 who responded who don't have a mask or glove requirement. That I'm surprised about. I thought that would be 100%.
Yeah, interesting. Okay, well, that was just more of a check-in, guys. And it looks like for our webinar participants, most are doing something different. They've adopted additional rules. So you, again, should be getting with your council. And that's what we're seeing from a boots on the ground standpoint as well. For sure, masks, lots of hour limitations, and number limitations would be the big 3. Fewer temperature checks, almost no indemnification agreements. So guys, we have about 20 more minutes. I want to respect the time of our participants. And there's 3 things we want to talk about now. And that is kind of the running of your association business in this environment, which is changing. Jeff, you talked a little bit earlier about meetings. We had a question from our participant. We continue to receive questions. So as a refresher, Michael, if you could just review, what effect do the emergency powers have on notice requirements for the boards and meetings? Do they still have to properly notice? Take us through the rules.
Yeah, and I think Jeff touched upon this earlier. The emergency powers, they do not eliminate the requirement for proper notice. The emergency powers, when it talks regarding notice, talks about you're noticing in the most reasonable means necessary. I think, I will say, I think generally, well, let me offer this. This, again, to your point early on, Craig, this is general guidance. I think if you have a specific situation, you definitely want to touch base with your counsel, and don't burden your manager asking your manager what's legal and proper. Go to your legal counsel and ask them for a quick opinion or quick guidance on this. But in general, when you're talking about meetings, board meetings, or even membership meetings, the notice requirements remain in place. 48-hour notice or 14-day notice, depending on what actions the board is looking to take. Membership meetings depends on condominium co-ops, they're 14 days generally. HOA, depending on your governing documents, maybe 14 days, maybe less, but you are following those notice requirements 100%. In the situation, if you have an urgent situation where you need to take some action immediately, then you might do something, then you're calling what's called an emergency meeting. That has nothing to do with the emergency powers per se. It's an emergency meeting, but that doesn't mean you're still noticing. And then, as Jeff pointed out, you're looking to ratify any urgent action at a properly noticed meeting of the board. So those notice requirements 100% remain in place. And so you definitely should, and what that means also is not only are you noticing 48 or 14 days, you're following all the requirements of a meeting, meaning members are allowed to attend and members are allowed to speak on those agenda items, unless there's exceptions. If you're talking about personnel matters, board can close that meeting. It posts notice of a closed meeting. If it's a meeting with legal counsel to address litigation matters, either pending or potential, that's a closed meeting. You're still posting that notice. But other than those meetings, you're having an open notice meeting where members are allowed to attend and speak on those items when the board directs that it's their time to speak. It shouldn't be a free-for-all. And so and we'll get into this more, but when you're doing electronic meetings and things of that nature, those requirements are all still in play. Proper notice, proper allowance of attendance and speaking.
Michael, thank you. And Jeff, I think you made a great point before, which was, yes, you have emergency powers, but to the extent you can properly notice a meeting, you don't have an emergency that you have to deal with, go ahead, follow the regular statute. Don't enlist the emergency powers to do it. So I think that was great guidance. Right. To get into some specifics, a lot of boards are holding meetings like on platforms like Zoom, like we are today. So Jeff, I wanted to ask you a two-part question. One, is it acceptable to hold meetings on these types of platforms? Do you have to have them in person? And then two, I know there's an issue with respect to owners being allowed to speak on agenda items. And the one question we've been asked is, Zoom has a chat function. Some of you are chatting in questions. Is that sufficient platform to, meet that obligation of the association?
Wow, that's a great question. What was your first question, Craig? We'll come back to the second part on Zoom.
Zoom meeting?
I think you can have the Zoom meeting. However, with that in mind, as long as you are complying with all of the statutory meeting requirements, which kind of tags into and dovetails into your second question, right. I would prefer, in a perfect world, in a perfect environment, that the association adopt into its bylaws a provision regarding holding the Zoom meetings and processes for it. I think that will solidify things. Do I think it's a failure that a meeting didn't occur because the meeting actually occurred on Zoom and the board took action on Zoom and all other statutory requirements were met except the meeting was on Zoom? Would that invalidate the meeting? And no, I don't think it will. In regard to asking questions, I think before we get to how you ask the question, be it typing it in through the question and answer on Zoom, first question is, we deal with a lot out in the field, is when should the member be provided their opportunity to speak? Should it be like a governmental setting before the meeting and everybody lines up at the podium to say what they want that's on the agenda? Should it be when the board is considering the item, or should it be at the end, the good and welfare? And it surprises me sometimes to still find associations out there doing it at the end of the meeting at good and welfare. And to those associations, I say, well, that really flies in the face of the legislation in the first place. So do it in the beginning. I don't love it. Do it when the board is considering an issue. And we write rules for our clients, Michael and I and the rest of our lawyers, all the time. And very, very simply put, if the board is going to consider and talk about an item and no motion is made, then prior going on to the next agenda item, we will entertain any member comments. But if a motion is made and it receives a second, then the board will continue to speak ad nauseum until it is done. Then we'll solicit member comments. And there's a whole list of rules that go with those member comments about acting like an officer and a lady, officer and a gentleman. You can't give your time to somebody else, all that kind of thing. And board, you aren't obligated to answer, but you can answer if you want to. And finally, no inciting a riot. But after the member comment, then it goes back to the board for final conversation and the vote itself of the board. Now, exactly. If you are only allowing your members to participate, asking questions electronically by having to type them onto a keyboard, when in fact they could be live participants at the meeting, I think that would be improper, and you should be encouraging the live participation of the members. But if you have a situation where that is not possible, and the only mechanism you can provide to the member is to electronically type it in, I guess in a pinch that might work. But as a way of regularly doing business, no, I would not think so. Michael, what do you think?
Yeah, no, I think that was all spot on. And I want to just reiterate what Jeff said. I think it's very important that boards do get with counsel and consider, if you haven't already, adopt rules that statutes encourage. Have reasonable rules in place that guide your meetings, especially in today's environment. And I do think, well, I want to point out, there was a question, hey, what if someone doesn't have a computer? You're doing these Zoom meetings. I want to remind everyone with these meetings, there's always a call-in option. So as long as someone has a phone, they don't have to necessarily be on a video. They could be on a phone and they could hear everything and they can speak just to, the statutes absolutely have always allowed for, telephone, the board members to call in and do a speakerphone type meeting. in this environment, if you're doing a Zoom meeting and you're inviting people to attend by Zoom, that gives a phone number where people could also call in. So there's that. The other thing is the question that was asked about notice, I talked about real quick. It is a 48-hour or 14-day notice for your board meeting, depending on what action you're taking. But I think that you're spot on, Jeff. I 100% agree with the process that you talked about. I think it's best if boards can conduct meetings with, here's the agenda item, we discuss, members discuss, we bring it back. And for a member, if they don't want to speak, they want to put, I would say, listen, if you want to put your question out, we will ask your question and answer it. But if you want to speak, there's a hand raising or some kind of feature, and give that individual an opportunity to actually verbalize their question or comment.
And Mike, you brought something up that's very, very important. Going back to the speakerphone example. So the board's having a meeting, the entire board is everywhere around the world. And the manager then takes a speakerphone, puts it into a common room, and anybody that wants to listen and participate can come into that common room to listen and participate. And I suppose Zoom has made that possible by never having to set up that common room. And I would then like to suggest two things. One, we need to amend the legislation in that regard to really provide that you don't have to have that common room, because I think if we go back and we look at certain parts of 718 and 720, it might suggest to us that we have to have almost like a Zoom platform in a common room for people to come to and listen and observe and participate, which is sort of oxymoronic when you can do it at your house, which wasn't possible when that legislation was written in the first place. So it's really, really interesting whether or not the association still needs to comply if they have a Zoom meeting, and it's possible to have an iPad, a computer in a common room, so people that don't have a computer can come in and listen. Maybe that's something we need to look into as well.
Right. Although, like I said, I think because you can call in, no one has to be able to see us. Right. You can just call in, so you don't need necessarily. That's my thought on that.
Because I think the bottom line is we do have some questions like, should you be holding meetings? And our advice is absolutely you should be holding meetings, even if you can't have them in your tiny clubhouse because you can't respect the social distancing rules. There are tools. We're hosting a ton of Zoom meetings these days for our board.
Us too.
Which is fantastic. It really increases the reach of the association to the members, which I think is
our board meetings. You think I'd know better? I'm on the board of my HOA for 8 years now, and ever since we started having our meetings on Zoom, everybody is so much more pleasant. Both owners, board members, everybody, and the meetings are more efficient. We get more business accomplished. It's incredible. Yeah, so it's been a nice tool. It's been a nice addition to the arsenal.
Yeah, I think, and they continue. We're going to ask that question after. Okay, I want to move on to electronic correspondence. So what we are seeing is from our clients a real embrace of technology solutions in conducting association business. Some of the tools have been around for a long time. I want to talk a little bit about an owner's ability to elect to receive official correspondence of the association by email or electronically. Rose, can you post poll question number 15 for me? Does your association have a program to allow owners to receive official correspondence from the association electronically? And then Jeff, I do want to get to electronic voting quickly, so we're going to run through this pretty quickly, but what does the statute say about owners being able to make this election?
Very, very simple. All you need to do is have the owner sign an 8.5 by 11. I opt to receive all of my official notices from the association electronically to the following email address. And that's all you need. You need their signature on that piece of paper. You could, theoretically, you could even email that piece of paper out, I suppose, but you should provide it to everybody at their official mailing address as well. You want to get as much compliance as you can. And then at the same time, and I'll dovetail this into your next question, into number 5, electronic voting.
Before you do that, Jeff, before you jump to electronic voting, let me just add one thing. I would also add, I think that in addition to having them sign it, I like the idea of having them, here's my email address.
Oh, yeah.
And then sign it.
You got to
so that you have it. So when someone said, because the important point of this that everybody should know is when you agree to use your email, your email address as your official notice, that becomes part of the official records that's open to inspection and copying. So everybody then has that email address. So if you are, so some owners, maybe you want to consider having an email, creating your own email address specific for your association, and then use it that way, then that's then as opposed to your personal email or a business email, because that email address is open to inspection. And I've had people, we've had, Jeff, I'm sure as well, we've all had this where well, why is my email address given out? They need to know in advance, this is part of the official records open to inspection. So I like having a piece of paper from them that says, look, you wrote your email, you signed this. That's the reason why it's now open to inspection.
That's right.
I think the big, that's, by the way, if you post the results, Rose, if you don't mind, we see now a majority of associations doing this,
Nice.
which I know makes all the treasurers in the room happy, because a lot of it is cost driven. And I will tell you, by way of example, can you just move the question? Please, thank you. I will tell you by way of example, an annual meeting package can cost, $10 when you get a bunch of resumes and pictures and biographies and all of those types of things. So it is a big cost. And I know from a property management standpoint, our platform tracks all that, because it's no good to get the election and not have it and then mail it to everybody. So the way it has to integrate with your information communication system to make it really work. So I want to move on to the last topic of the day, and we're going to give it not enough time, so maybe we revisit it again. But electronic voting, it's been around for a while, took some time to get some traction. We see it really picking up at this point in time. Particularly relevant topic, given that we're in fast approaching the annual meeting season, if you will. Rose, before we get to the specific guidance from the guys, can you post poll question number 17? Does your association allow for owners to vote electronically? And then, guys, I want you to give us some guidance, if you can. Jeff, specifically, do the statutes provide for electronic voting? And what about the association documents?
The statutes certainly provide for electronic voting. You don't have to amend your governing documents to do electronic voting. When you're sending around the 8.5 by 11 to people so they can provide their signature and email address if they want to receive their notices electronically, also on that exact same piece of paper should be a place for the owner to opt into the electronic voting when the association board chooses to use it rather than mail voting. But paper voting. Right. It's very easy to do at the board level. There's all sorts of requirements for the companies providing these services to separate the identity from the vote, from the voter, and things like that. And there's some board responsibilities. It's incredibly simple to do. A quick phone call with your lawyer, a letter back to the board, and you're off and running. Mike, you want to add into that?
Yeah. I mean, it's interesting. I see that we have, of the 100+ people who responded, 84% are not doing electronic voting yet. I look at that quite frankly, though. I like to see at least there's 16 who are, because I think a year ago that number might have been 5. So
well,
I think
it can cost $1,000, right, Mike? About $1,000 a year for electronic voting from a competent service.
Yeah, I mean, right. Well, to that point, there's a few other points. Like board has to adopt a resolution, and there's a 14-day notice requirement for that board meeting where the board's going to adopt a resolution to allow for electronic voting. And again, get with your council. As Jeff mentioned, I mean, we have been asked this. We have a very simple process. We create the forms that our boards can use to implement electronic voting should they desire. And reminder to everyone, electronic voting doesn't become you have to do it. It's an opt-in. So there would, some may not, and you can opt in or opt out. There's no, for any meeting. So once the board's adopted that, obviously it's important to get a reliable third-party vendor who's experienced in this arena. And there's a few companies that we've vetted that we think do a good job with that. I'm sure Craig Newcastle has similar companies too. And get all that in place. And I want to point out one other thing. While annual meetings, I think it's helpful. I think this is a great tool when you're trying to update your documents. To me, that's even more than the annual meetings. Being able to update your documents, I think, is really important to have electronic voting as an option, because it really allows you to get people will hopefully be more willing to review and vote electronically on those items.
So guys, let's post the results, if you don't mind, Rose. So
they're up there.
Large number of associations still not embracing this technology yet. I think if everybody who embraced the electronic correspondence side embraced the electronic voting platform, we'd see a change there.
There's another benefit to it too. Electronic voting for all of you HOAs and condos out there. When you bring Mike and I to an election, it's either because of, usually it's because it's either a huge election and you need the guidance, or you have a contested election, no matter how big you are, and you need guidance there. And then the envelopes have to be open and things have to be counted. And before you know it, you have an attorney with you for 3, 4. I've had meetings that start at 6 in the afternoon and have ran till 2 in the morning for elections. Whereas, had they just done electronic voting, in 30 seconds, poof, the manager pushes a button and there's the results. Big difference.
It is a huge difference. And I will say on this issue, and Michael, I think you made a good point. One, it's not just a question of saying, okay, let's go. You have to have a properly noticed meeting. to have the board adopt a resolution that the association will allow electronic voting. Do I have that right?
Yeah, and that resolution also will provide guidelines to the community, to the members. It'll say X number of days before the meeting, we're going to send out a notice if you want to opt in or opt out at that point. And there'll be a lot of communication between the board, the community, and the residents when necessary. But the idea, but it is simple, as like Jeff pointed out. If you choose to opt in, it's one time only. You opt in and you can electronically vote as long as the process is available. You don't have to opt in every single vote.
So the board sets the framework. They say you can do it. Then we send a correspondence out to the owner to have them opt in or opt out. As your management company, we track all of that in our software. And then you do need to find a vendor, and there are several vendors out there that do this. We can help you. Your attorney can help you. I will say that there are a couple of cost models. There's the license fee model, where you pay one license fee and you get an unlimited number of votes. The other is a per vote type of model. Depends on what you're doing. We're with you, and then we've seen some huge success on getting amendments signed or adopted, if you can, where you used to have to kind of resend everything if you didn't get their votes, and now the online voting platform kind of allows you to ping owners who haven't voted yet, so it's a huge advantage, big cost savings to your point. The annual meeting process is still a little bit cumbersome, because you still are allowed to vote by snail mail, Jeff, by paper, as you said.
Yep.
So there is a process at your meeting of merging the votes, and we do recommend that you do have your attorney there to answer the one guy who walks in with, I voted electronically, but I now want to change my vote, and how you deal with that. And attorneys are much better at dealing with that issue than property managers.
Right. 100%, Craig. But to Jeff's point, and I've been there too, trust me, we're not thrilled with being at meetings for 5 or 6 hours. Yeah. The fact that we might be getting paid for being there doesn't at all change that fact. So I would love that we come to the meeting, and within a 2-hour window, we're able to do everything that normally took 4 to 6 hours. Or, so that would be, by the way, to one question, ballots, any materials on voting need to be maintained for 1 year. It's part of your official records, to answer that question. And for electronic voting, how are you, if some units don't have computers, remember, electronic voting isn't an all or nothing. It is an option. So if someone doesn't have a computer, they will not opt into electronic voting. They will continue to vote by paper.
Yeah, and once you find a vendor, by the way, the other point is, when you find a vendor, the vendor software talks to the property management software like that we maintain, so you don't have 2 separate sets. You kind of have one integrated system that says, okay, this person's getting a hard copy ballot, this person's voting electronically. So I think it's a great platform. Not very much adoption yet, but I think we'll see more and more of it as we're embracing the Zoom meeting technology and those types of things. Guys, we're running a little over. One last question. I just want to poll our audience, number 16, Rose, if you don't mind. Do you foresee using electronic processes platforms past COVID times? And so let's see just how much our residents or our listeners are going to embrace technology. While they're answering that question, Jeff and Michael, any last comments for today?
So many, but we'll hold them for our next one.
I just want to thank everybody for showing up today and listening for a little bit.
Well, Jeff and Michael, as always, thank you very much. For our webinar participants, we really appreciate you logging on and listening to us. Just so you know, if you could post those results, 90% of these associations represented today expect to continue to utilize some of these electronic tools. So guys, I will sign off. We'll see you in a couple of weeks. We're back at 12
Thank you again, everybody. Sorry we couldn't get everybody's questions, but we'll keep trying, and appreciate you guys coming, and everybody stay well.
I gotta come
Wear a
back.
mask.
Absolutely. Absolutely. Take care, everybody.
Bye, guys.
Bye now.